Whoever's logged in as D. Parker, can you tell me who the defendant is at your facility so I can change the name? Hey, how are you doing today? I don't know if you can hear me or not. I'm the court administrator for Judge Martin. Tell me your name so that I can change it on the screen.
Zachary Bird, Zachary.
I'm sorry, I didn't hear you.
Zachary.
Okay. Okay, and then Judge will be with you here in a minute, okay? All right, thanks.
Oh, yeah, no, I already asked for question for you. Yeah, that's. Yeah, no, what happened? Where you going? Oh, okay. You offer. There's something. I think it's fan hoax. Last time it was pretty soft. People know. His face is always so good.
Recording in progress.
Just one moment. Test. All right, is Mr. Manning available for Mr. Byrd?
Ready, Judge?
Okay, all right, court call CR 2148, CR 21108. Sir, state versus Zachary Dane Byrd. And court will note that Mr. Byrd is appearing from Rockwall County via Zoom. Appreciate the Rockwall County staff for assisting us with this Zoom call. We're set for status today, Mr. Manning, go ahead.
Judge, at this time, we have not had an opportunity to go over indictment or any of the discovery. Mr. Byrd has been in Rockwall County the entirety of my appointment to his case. If it's possible, if we could pull up a copy of the indictment, I could arraign him at this point. But as of yet, I'm unsure as to his status there in Rockwall County.
You believe that Mr. Byrd needs to be arraigned on both cases or just one?
Judge, I haven't arraigned him on either case at this point.
Okay. Byrd, can you see this document on your screen?
Yes, sir.
Okay, I'm gonna give you just a moment. Can you read, sir? Mr. Byrd, can you read?
Yes, sir.
Okay, I'm gonna give you an opportunity to read that for just a moment, and then Tell me when you need me to go down on the card.
Okay, yes, sir. Okay, yes, sir.
That's the bottom of that document. For the record, the court has displayed indictment in CR 21-108 to Mr. Bird. Mr. Bird, is your name still correctly here in the body of the indictment?
Yes, sir.
And it appears that you are charged with a third-degree felony offense of possession of a controlled substance and penalty group 1 between 1 grams and 4 grams, a third-degree felony, which if convicted and sentenced on that crime, you could be facing the range of not less than 2 years in prison up to a maximum of 10 years in prison. And it appears that these enhancement paragraphs, if proven true, could elevate your range of punishment. I believe Ms. Heisel, is this raising it to a first degree?
Your Honor, I believe it raises it to 25 to life.
Okay, so potentially you're could be looking at a minimum 2 to a maximum of 99 years or life. And if proven true, your minimum could be elevated to a minimum of 25. Okay, do you understand the range of punishment and what you've been charged with? And the state's alleging in this indictment
No,
that,
sir.
Wilson, will you close that door? You see here the state is alleging that you possess controlled substance, namely methamphetamine, in an amount of 4 grams or more, but less than 200 grams. Do you understand that?
I understand the top part, but I don't understand why it's 25 to life.
Okay, so this top part here alleges a third-degree felony offense. A third-degree felony offense has a range of punishment of 2 years to 10 years. If you have previous criminal convictions, if those are alleged and proven true, then that could increase your range of punishment as a repeat felony offender or a habitual felony offender. If proven true, then your range of punishment could adjust upward.
Okay, yes, sir. I understand that part, but I thought that the charge had to be the same. So they can enhance me on that from 2010?
I'm gonna let you talk to Mr. Manning on that. I'm just explaining to you what's been alleged and why I'm telling you what the range of punishment is on that one, okay? And so, Mr. Manning, would you like to enter your client's plea on this case?
Judge, at this time, he's pleading not guilty.
All right, court will enter Mr. Bird's plea of not guilty to the record in CR 21-108. Court now is going to display the next. Can you see this one, Mr. Bird? Do you see the indictment in CR 21-48?
No, sir. It's the same thing.
Same thing? Okay. Try this again. How about now? Do you see the indictment in CR 21-48?
Yes, sir.
Okay, go ahead and read this one.
Yes, sir.
Okay, and then the enhancement paragraphs.
Yes, sir.
Okay, so this is similar yet different than the other indictment. Same charge of rather than possession, they're alleging either that you manufactured or that you delivered a controlled substance, methamphetamine, in an amount of 4 grams to 200 grams. If manufacture or delivery of this charge is proven, then that elevates it to a first-degree felony offense. And then the first-degree felony offense, which carries a range of punishment with a minimum 5 years in prison up to 99 years or life in prison, can further be enhanced by prior criminal convictions. If proven true under the applicable law, then your range of punishment could be then elevated again to repeat felony offender or habitual felony offender And your range of punishment you're facing could be minimum 25 years up to maximum 99 years or life in prison. Is your name spelled correctly in this indictment, sir?
Yes, sir.
Okay. And Mr. Byrd, you understand what you're charged with?
I understand what I'm charged with.
Okay. Mr. Manning, you want to enter your constant plea on this case as well?
Judge, he pleads not guilty to that case as well, and request to be set on the pretrial docket.
All right. Court enters Mr. Byrd's plea of not guilty in CR 2148. Court will set Mr. Byrd for pretrial. Mr. Manning, do you know how long Mr. Byrd may be in Rockwall County?
No, Judge, this is the first time I've had contact with Mr. Byrd in Rockwall County.
Okay, so I'm going to set in November 10th for pretrial. That'll give you time perhaps to be in contact with Mr. Byrd. Mr. Byrd, if you're still in Rockwall County in November, then I will ask them to Zoom us again, just like we are today. Okay, and Mr. Manning will try to be in contact. You need to reach out to him. I believe, do you have Mr. Manning's contact information there with you in the Rockwall County Jail?
I had no idea that's my attorney.
Yes, your attorney is Mr. Manning, who's appearing on the screen here. He's your court-appointed attorney.
Okay, yes, I never had no idea.
Okay, Mr. Manning, will you be able to get in contact with Mr. Byrd and give him your contact info?
Yes, Judge, and I'll see if I can reach out, schedule a Zoom appointment to go over his discovery prior to the pretrial setting.
All right, thank you, Mr. Manning. All right, Mr. Byrd, if you make bail there in Rockwall County and also in our Van Zandt County cases, if you're out of custody in November, then your hearing will be at 9 a.m. on the 10th. If you're not out of custody, then we'll come to you at 1:30, okay?
Okay, thank you, sir.
All right, thank you, Mr. Byrd, and thank you to the Rockwall County staff. All right, do we have any other counsel that's ready?
Judge, I'm ready on 5 of mine right now.
Okay, who do you want to go with?
Mr. Classen, Michael Classen.
Michael Wayne Classen, CR 22173. Mr. Classen, set for pretrial. Go ahead, Mr.
Yes, Judge. We have no contested pretrial. We reserve the right to file any pretrial matters that may arise between now and docket call. We request that we be set on docket call. We've also requested an offer on his case and have yet to receive one at this time.
All right, and Ms. Heisel, do you know if there's an offer in the case?
Judge, it is assigned to Mr. Woodwike, and it does not appear that there is one in the case.
Okay. All right, well, if the state is going to make an offer, I would just ask that it be made well in advance of docket call so that they can consider that fully. Mr. Manning, I would be setting on October 13th. Any objections?
No objection, Judge.
All right. Court sets Mr. Classen then for docket call on October 13th at 1:30. If you're on bail, Mr. Classen, it'll be at 9 a.m.
Yes, sir. Ready on Mr. Jesse Griffin.
Jesse John Griffin, CR 22215.
Judge, same announcement on Mr. Griffin. I reviewed the discovery, spoken to my client about it. We have no contested pretrial issues, but request to reserve the right to file any that may arise between now and docket call. Request for docket call, and we still need an offer on Mr. Griffin's case.
Ms. Heisel, will you check this case as well, see if there's an offer?
Judge, same announcement on this case.
No offer made yet? All right, court will set Mr. Griffin also for October 13th.
Judge, ready on Mr. Hoover.
Go ahead, Mr. Manning. Who is this? Mr. Hagan?
Eric Hoover.
Oh, Hoover. All right, Eric Ashley Hoover, CR 2268, set for docket call. Go ahead.
Judge, Mr. Hoover has an additional case that we are trying to work out a resolution on in conjunction with this case. I have conveyed the offer to Mr. Hoover and at this time he is requesting that we review the discovery report. He takes that offer. I have not been able to view the discovery for the unindicted charge. And so we request that we continued on docket call so we could get these both on the same track.
And you said the unindicted charge is here in Van Zandt County?
That's correct, Judge.
And what kind of charge is that?
Theft charge, Judge.
Theft. In state, do we anticipate that this unindicted charge will become indicted?
Judge, I show actually that there are 6 new theft of material charges and that we have not received any of them in our office. We have the jail book-in paperwork showing he's been booked in on those charges, but that's all the information that the DA's office has at this time. And it appears they occurred at various dates in June of 2022.
Okay. All right, court will reset Mr. Hoover. Well, let me ask this, Ms. Heisel. Is the state going to give Mr. Manning access to the unindicted cases so he can review those? When you get them, do you have any of them?
We don't have any of them, Your Honor. The only thing that we have in our office is the charge that is currently indicted and on the docket today. We would have no objection to giving Mr. Manning that once we receive it, but we don't currently have it. It also looks like, I don't know when he was arrested on these, but at least the date of offense of these were hovering around 90 days on those. So if Mr. Manning will just get with us, I'm sure we can figure out what the resolution on that needs to be.
And do you know what agency it is that's not turned in the report?
Let me look in here and see if the PC affidavit should state it.
Judge, I believe it was Point PD.
Judge, it looks like it's the sheriff's office. I see Sergeant Pollard's name on here
On the PCF?
for at least one of the charges. It may have been multiple agencies. I don't know.
Okay. All right, so what I'll do is, I know that this is the 5th setting. I'm gonna set it for a final docket call. If the cases aren't in, we can't wait, we can't wait forever because cases may not be turned in, they may be dropped. Regardless of whether he has new cases or not, we got to move forward on this case. So court will reset for a final docket call. And we'll set that on, do you want the November date, Mr. Manning?
Judge, if we can actually have the October 13th date, my hope is that if they do not get a case, we can get something resolved between now and then.
How about this? Let's set it for the November 10th to give you more time to wrangle these things. And if y'all get it before then you'll contact me and I'll put it on the 13th. Otherwise, I don't want to set it for the 13th and then need another request for time to the 10th. So
Yes,
I just want to set it for November 10th. And if y'all get something worked out before then, you let me know and we'll move it up sooner. Any other clients, Mr. Manning?
Yes, Judge, have the paperwork ready on Mr. Large.
Okay, if you're ready, I am.
And then I'll also have the paperwork ready on Mr. Wilson.
All right. Jacob Large, CR 22-314. And Ms. Heisel, can you give me the terms, or Mr. Manning, can you give me the terms of its plea agreement?
Yes, Judge. This case was filed by information and we waive indictment. It's going to be proceeding under 1244A with a time served, 72 days in county jail with credit time served, fine of $1,000.
Court costs?
$290.
Any reimbursement?
515.
515?
That's correct, Judge.
All right, Mr. Large, if you will, sir, raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Jacob Dale Large, is that right?
Sir.
And Mr. Large, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
Like you've had enough time to discuss the case with him, have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Say that again?
No, sir.
Okay. And have you ever been diagnosed with any type of mental condition?
Yes, sir.
Okay. Mr. Manning, do you believe your client to be competent today?
He is, Judge.
And you've explained to him his rights as they pertain to this case and any waiver of those rights he's making?
I have.
Mr. Large, it appears that you would be pleading today guilty by information rather than indictment. Do you understand that anyone who is accused of a felony offense enjoys the constitutional right to have their case presented to a grand jury, and for that grand jury to determine whether there's sufficient evidence to believe that the crime was more likely committed than not by you? You understand that?
Sure.
Means all cases that get indicted must go to the grand jury. However, you can waive your right to have your case taken to the grand jury, and you can allow the state to prosecute you by filing an information. And that's what Mr. Manning has told me you want to do today. Is that right?
Sure.
Has anyone threatened you, forced you, or pressured you to make you feel like you had to waive your right to a grand jury?
Yes, sir.
Okay. And you heard Mr. Manning read out the plea agreement. Is that your understanding of what the plea agreement is and what you're asking the court to approve?
Yes, sir.
If I approve this and we let you out of jail, are you going to show up and pay your fines, your court costs, and your reimbursement fees?
Judge, if I may, he's actually on his way to TDC. And so there may be a bit of a delay. I explained to him that fine the court costs will follow him down to TDC. And then if he doesn't get those paid off, he'll need to proceed back here and be able to pay those once it gets done.
All right, thank you, Mr. Manning. And Mr. Large, you understand that under this plea agreement, the maximum time that you could spend in jail is up to 1 year. However, the plea agreement is for you to serve 72 days and receive credit for that. And you understand that, correct?
Yes, sir.
All right. Understanding the plea agreement, the range of punishment, Mr. Large, how do you plead to theft of property greater than or equal to $2,500, but less than $30,000, a state jail felony?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty today?
Yes, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection, states one.
All right, state's one is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Judge, just briefly, may I call my client?
You may.
Mr. Large, you understand that we kind of put a move on this case at your request, is that correct? And you understand that there were some potential defenses that may have provided either mitigation or provide total defense, legal defense to this offense. But you have insisted and have requested that we move forward, get this case taken care of so you can get on down and take care of your time. Is that correct? Yes, sir. Okay. And you understand that we're waiving any and all defenses that we may have had in order to take this deal today. Is that correct? Sir. And you're fine with the time frame that we're able to do this in? Sir. Okay. No further questions, Judge.
Ms. Heisel, any questions?
No, Your Honor.
Okay. And Ms. Heisel, can you give me the facts to support the plea?
Yes, Your Honor. On July 13th of 2022, Grand Saline was attempting a warrant service on Mr. Large. When they made contact with him, he was next to a motorcycle. In the process of serving the warrant, they ran the temporary tags that were on the motorcycle, and it came back entered as stolen out of San Angelo And he, Mr. Large had said that he bought that bike out of San Angelo, but had no supporting documentation to it. He was placed under arrest for the theft of that stolen vehicle.
Thank you, Ms. Hyde. Any objections to that summary, Mr. Manning?
No objection, Judge.
All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Large of this offense. The court will follow the plea agreement. Court hereby convicts Mr. Large of the state jail felony offense of theft of property, $2,500 to $30,000. Court imposes sentence under section 1244A of the Texas Penal Code at 72 days confinement in the Van Zandt County Jail. Court will award him 72 days credit for time previously served, order him to pay a $1,000 fine, $290 court costs, and $515 reimbursement fees. Mr. Large, when you are released from TDC and once you're a free man, you need to make your way back to Van Zandt County as soon as possible so you can make arrangements to begin a payment plan to pay off what you owe. Failure to do so will result in a warrant being issued for your arrest. Do you understand, sir?
Yes, sir.
Okay. All right, Mr. Large, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with Deputy Everett to be fingerprinted. All right, Mr. Wilson, if you'll step up. Just one moment, Mr. Manning. You can get your next client up there, but I'm going to talk with Mr. Wilson real quick. All right, so Mr. Wilson, your client is on this morning's docket. All right, court this morning had called CR 22-111 Charles W. Massey, and the court had his name called at 9 o'clock. He wasn't here. The court called his name towards the conclusion of the docket. He wasn't here. And you asked the court to take an eyesight under advisement until 1:30. The court has done so. The court knows that it's approximately 2 p.m. now. And Mr. Massey, is he here at this time?
He is not, however, I have been in communication with him. He indicated that to me that on the way here, while they were driving, the stud on his vehicle blew out and popped the tire. He did send me some pictures if the court would like to take a look at those.
When did he send those to you?
He sent those pictures to me at 1:50, Your Honor.
And this occurred before 9 a.m.?
No, Your Honor. I believe he was on his way here after I spoke to the court this morning. And then between the time I spoke to him this morning and conveyed that information to the judge and now is when the call trouble started. So I would ask that in speaking to him, the advice he could make it here tomorrow morning at 9 a.m. I'm set to be here as well for another matter. I would ask the court to hold off on issuing an eyesight until 9 a.m. tomorrow.
Any objection from the state?
Judge, state's going to take no position. We had no objection to letting him appear at 1:30. I kind of find it awful convenient that he's not here. But if if the court wants to hold it until 9 o'clock in the morning, state has no objection.
Okay.
And again, Your Honor, I do have some pictures if the court would like to take a look at those.
No, I'm gonna extend the courtesy to Mr. Wilson to Mr. Massey on Mr. Wilson's behalf. So court will take the judgment and eyesight under advisement until 9 a.m. in the morning. So he's ordered to appear in this court no later than 9 a.m.
Yes, Your Honor. Thank you.
You're welcome.
Convey his, I know my client appreciates it. I will convey that information. To him as well. And that's all I have on the docket, Your Honor. May I be excused?
Yes, thank you, Mr. Wilson.
Thank you.
All right, Mr. Manning, who do you have now?
This is Mr. Wilson.
All right, court calls State versus Bryce Taylor Wilson, CR 22-258, set for arraignment. Go ahead, Mr. Manning.
Judge, we are actually proceeding on a plea. I would note for the court and for the DA's office, it appears that there was a mistake on the plea paperwork, both on the judgment as well as the stipulation. We are proceeding, he has been indicted and we're proceeding under that indictment. It says it's proceeding by information. So I just want to point that out to the court before we proceed. The terms of the agreement are that he plead guilty and that punishment be assessed at 6 years TDCJ institutional division, a fine of $2,500, which includes the $100 family violence fine. There's court costs of $209 and a reimbursement fee of $35. Additionally, he has 119 days credit. And this sentence will run concurrent with any and all other sentences.
And are there other sentences?
Not in this county, Judge. And I did have a question from the state earlier about there was potentially another charge that was out there from Van Zandt County. I don't see a resolution for it in the paperwork that I was given. And if we need to recall this case, I can step out and speak to Ms. Heisel about this. But my understanding was that the allegations for the other charge occurred while Mr. Wilson was in state jail. And so we would be asserting a defense if we would proceed under, or if they want to proceed under the additional charge. So I don't know how the state would like to proceed on that.
Judge, the state, well, there's a filed misdemeanor charge in the county court at law. The state will dismiss that charge with the plea in this case. The judgment will have to be corrected. I can see if Miss Abney is available to try to get that this afternoon, but it may be tomorrow before we can get a corrected judgment. Since it is a TDCJ sentence, I know we will have to correct that judgment.
Okay.
And Judge, with that understanding, we'd be willing to go forward on the plea as long as we get that corrected judgment indicating the dismissal of the evasion arrest.
Okay. All right. And you said that there was an issue with the stipulation as well?
Judge, it just has the same language that that he's pleading true to everything that's contained in the information, and that should just read indictment.
All right. So you can mark the stipulation out and write indictment on that.
Judge, I have interlineated both.
Good. Mr. Wilson, sir, raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. You can put your hand down. Mr. Wilson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Bipolar and depression.
Okay. Are you currently on medication for either of those?
Yes, sir, I am.
Do you feel like you have a rational understanding of what's going on here today in court and what's going on in your case?
Yes, sir.
Okay. And your attorney is Mr. Manning. Are you pleased with him being your attorney?
Yes, sir.
Do you have any questions for him or any questions for the court or any questions about any of the paperwork that you've read and signed today?
No, sir.
Okay. Mr. Manning, do you believe Mr. Wilson to be competent today?
He is, Judge, and my multiple conversations with him, I've not had any doubt as to his competency.
And Mr. Wilson, you heard Mr. Manning tell me what your plea agreement is. That's what you want the court to approve today. Is that right?
Yes, sir.
Mr. Wilson, the charge of assault of a pregnant person is a third-degree felony offense and does carry a range of punishment of not less than 2 years or more than 10 years in prison. And I would find that the plea agreement at 6 years TDC would fit within that range of punishment. In addition, a $2,500 fine would not violate the range of punishment for fines in your case, which could be up to a maximum $10,000. So I would ask you at this time, Mr. Wilson, how do you plead to that charge?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, do you have any objections to states one?
No objection to states one.
States one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
And victim notification?
There is an A and P on file from the victim in this cause, Your Honor.
Thank you, Ms. Hyde. Anything further, Mr. Meany?
Nothing from the judge.
All right, Ms. Heiser, when you're ready.
Pulling it up. All right, Judge, this is October 13th, of 2021. I wrote my notes down wrong. Mr. Wilson's common law wife called police to say that he had beat her up this morning. She does have marks and bruises all over her. She alleges that he struck her with her fist, drug her across the bed, twisted her arm behind her back, and then beat her repeatedly with a belt that had a belt buckle attached. She does have bruises and marks across her back that are consistent with the allegations.
Thank you, Ms. Heidel. Any objections, Mr. Manning?
No objections.
All right, then based on the evidence, the court finds that there is enough evidence to convict Bryce Taylor Wilson of this offense. Court hereby convicts him of the 3rd-degree felony offense, assault of a pregnant person. The court follows the plea agreement reached with the state, imposes sentence at 6 years confinement in the Texas Department of Criminal Justice, a $2,500 fine, $290 court cost, $35 reimbursement fees. Court will award Mr. Wilson 119 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Wilson, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over with the deputies to be fingerprinted. Do you have any other counsel? If you're ready, you can step on up. If not, I'll bring in Mr. Fratter on Zoom.
We're ready, Judge.
All right, Mr. Green. All right. Court call CR 21-370 State versus Justin Lee Smith. So for docket call, go ahead, Mr. Green.
Judge, we are set for docket call. I would ask the court to reset docket call, and I'd like to have an opportunity before we go forward for Mr. Smith to watch the video of the incident so that he can make an informed decision concerning a plea offer that Ms. Curry has made.
How long has Mr. Smith had the plea offer to consider?
Probably a little less than a month.
Do you think that will be helpful to Mr. Smith in deciding whether or not to accept the offer?
I think it's, yes, Judge, I think it's something he needs to see before he either accepts or rejects the offer.
And what is the offer he's considering?
It's a 10-year probation, 10-year sentence, probated 5 years. And I had noted that on the reset form, Judge.
Okay, thank you. State your position.
Judge, Mr. Smith was just indicted for bond jumping. Mr. Boardwhite's notes say on August the 19th. And so I have no objection to one more reset, particularly since Mr. Woodwhite is not here to go over that offer and make sure all cases get resolved upon entrance of a plea.
Mr. Green, are you representing Mr. Smith on the bond jumping, bail jumping?
As of today, I'm not, Judge. I do need to visit with him about that, see if he plans on doing that. But as of right now, he is not, or I am not.
Okay, and Ms. Heisel, and you may not know because Mr. Green referenced it was Ms. Curry's case, but the bail jumping, does that at all affect the offer that was made?
Judge, if you'll give me just a second, I can look at my correspondence with Ms. Curry.
Because I would just tell you, the court would probably would not be inclined to put someone on probation who doesn't come to court.
I understand, Judge. Yeah. Can't ever find it when we're under the gun, Judge.
And Judge, I'm unaware if that offer predates the new charge or if that takes into consideration the new charge.
I'm sorry, say that again, Ms. Heisel.
I said I'm unaware if the offer predates the new indicted charge or if it includes the new indicted charge.
Judge, I have correspondence in here. Just give me one second.
Sure, yeah, no problem.
For some reason, I'm missing it. And I just looked at it before we got in here. The offer that Ms. Curry made, Judge, does take into consideration that failure to appear.
Okay. I would consider a short reset. Are you available on October 11th or 13th?
Judge, I am going to be, I'm set number 1 in Judge Evans' court in Palestine that week.
What about October 3rd?
I think we, actually, when I was here the other day, we set something on October the 3rd, I think. We did, Judge. I'm available.
Okay, well, let's do that. We'll try to knock out. Does that give you enough time to get to the jail and watch the videos with him?
It should, Judge.
Okay. All right. So we'll set Mr. Smith for final docket call on October 3rd.
Judge, we do have a request for bail reduction on this case, and we'd ask the court to hear from us today on that consideration.
Did you file that in at least 3 days in advance of today's hearing?
I did, Judge. I don't remember the exact. I think it was actually August 19th, I think is when I filed it.
State, do you have a copy of that?
Judge, I'm looking, I'm not aware of one, but looking to see if we have. it doesn't appear that we have one scanned into the case.
Was it Mr. Green?
Sir?
A writ?
Yes, Judge. On August, it was actually filed on August the 16th.
And it looks like it was served on Miss Abney. Miss Heisel. Not on the DAE file.
It should have been gone through e-file.
No, it was, well, it says it was served out to her email. All right, go ahead, Mr. Green.
Judge, I would call Justice Smith for the limited purposes of this bail hearing.
All right, Mr. Smith, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So, all
Yes, sir.
right, you can lower your hand. Go ahead, Mr. Green.
Mr. Smith, will you state your name for Judge Martin, please?
Judge Smith.
And Mr. Smith, you are here this afternoon asking Judge Martin to lower your bond in this case. Is that correct?
Yes, sir.
And you're currently in the Van Zandt County Jail, charged with by indictment, charged with evading arrest with a motor vehicle. Is that right?
Yes, sir.
And at the shortly after the time of your initial arrest, you were released from custody after posting the bond. Is that right?
Yes, sir.
And you were out of jail for many months prior to being rearrested for a failure to appear in court. Is that right?
Yes, sir.
And how long have you been in jail since your most recent arrest?
Since June 13th.
Of 2022?
Yes, sir.
And when you were arrested on the for not being in court on this case, your bond was increased to $40,000. Is that right?
Yes, sir.
And it's a fair statement that you're not able to make that $40,000 bond.
Yes, sir.
And you don't have the funds to do that. You don't have any family or friends that can post that bond for you. Is there an amount of bond that you believe that if it was lowered, an amount that you could make if it was lowered? Well, I understand, but
And Mr. Green, he's talking to you. I can't hear him and Miss Grisham can't hear him. So if I can't hear him, I can't consider it and she can't take it down and put it on the record.
I understand, George. Is there an amount on this evading arrest charge that you can make if it's reduced? $10,000 bond, you feel like you could make that? All right. And Mr. Smith, where do you live?
421. Grand Saline, Texas.
You live in Grand Saline?
Yes, sir.
And how long have you lived there?
You?
Where, prior to that, where you lived in Grand Saline, how long?
Now I'm staying with my dad, now I'm staying with my brother. I mean, I'm staying here now, so.
Okay.
I mean, when I get out of here, I'm probably gonna go back to my brother's house, and I'm not real sure.
Okay, what's your brother's name?
So, he's in jail, so my sister's staying there now. I mean, I'll probably get my dad in Jacksonville now.
I'm sorry, Mr. Green. I can't make out what he's saying. And if
Yeah.
you need to, sure you can do so, but he's talking low and fast and we're not picking up the word he's saying.
Yeah, you got to speak louder, Justin.
I think
So-
I heard you say his brother's in jail.
He
Yeah.
did. He did.
My sister's staying in his house. I mean, I'd probably go back there in Grand Saline. If not, I would go to my dad, which is in Jacksonville. Over there by Jacksonville.
What's your sister's name?
Christy Smith.
And your dad's name that lives in Jacksonville is Clarence Smith,
Yes,
correct? And if your bond is reduced and you get out of jail, you're telling Judge Martin that you'll be in court on October the 3rd at 9 o'clock.
Yes, sir.
Pass away, sure.
Ms. Heisel, any questions?
Just briefly, Your Honor. Mr. Smith, have you discussed with your family members where you would go if you were released?
Yes, ma'am.
Okay, so you keep saying you would probably go, and you've mentioned a couple of different places. have you gotten actual confirmation from any particular person that you would have a place to go if you were released with them?
Yes, ma'am. Father, Smith.
Your father in Jacksonville, is that correct? Okay,
Yes.
Your Honor, no further questions.
Anything further?
Nothing further, Judge. Just ask the court to grant Mr. Smith's request for bail reduction, reduce his bond to $10,000 surety in this case.
All right, thank you, Mr. Green. Ms. Heisel, any argument?
Just briefly, Your Honor, considering that the two charges before this court are for evading the police with a motor vehicle and for bond jumping, and the fact that Mr. Smith does not intend to reside here in Van Zandt County if released, we would ask that you hold his bond where it is. October 3rd is not far away, which I know is easy for me to say, but given Mr. Smith's track record, I do believe that there is a significant flight risk involved.
All right, thank you, Ms. Heisel. Mr. Smith, the court's going to deny your request to lower your bail in this case. The bail will remain at $40,000 for the reasons stated by Ms. Heisel.
Thank you, Your Honor. That's all our business today. May we be excused?
Yes, thank you, Mr. Green. We'll see you on October 3rd.
That's at 9 o'clock at the courthouse, or are we still waiting to see where we're going to be?
No, I believe we'll be here at 9 o'clock in the county courtroom.
County court. Okay. Thank you, Judge.
I'll have Mr. Smith brought over that day, perhaps.
Thank you, Judge.
You got next, Deputy Everett.
I have Miss Dobby for Mr. Fretter.
Okay.
You want me to bring her up?
Yes, go ahead. All right, Miss Dobby, one moment. We'll bring Mr. Fratter in. All right, I'm not sure about Mr. Fratter. I've asked him to start his camera, but he hasn't. So go ahead and have a seat, Miss Dobby. And I'm going to try to bring in the Henderson County Jail. Is Mr. Adams available in the courtroom? Oh, there's Mr. Fratter. Come back up, Miss Dobby. Maybe not. Oh, that's Jonathan. That's great. All right, Mr. Fratter, can you see and hear me okay?
Yes, Your Honor.
All right, this is State versus Shayna, Sapien, Dobby, CR 22-130-131. We are set for docket call today. And do you have any announcements? And can you see your client there, Mr. Fratter?
I believe she's at the lower left.
Wave your, yeah, and if you need to, you might be able to.
There she is.
Yeah, you can right click on her and it'll pin her.
Oh, okay. Thank you, Your Honor.
Yeah, go ahead. Any announcements on docket call?
Where am I at here? Okay, I guess I mean I can see her. I don't need her to get any bigger. I apologize, Your Honor. Judge, I guess my announcement for today is I can report that I've been provided the I think the first part of written paper discovery. I believe I have to send a portable device, which I was told by Miss I guess it's Heisel. Heisel, to get the audio and the video. You know, I understand the case has been pending for some time. I'm not trying to say we need another 7 months to get ready, but I certainly wouldn't mind the ability to get the full discovery. I believe there are going to be some subpoenas that I'm going to need to get issued for some phone records, text message records between defendants and victims. So at this point, I guess I would ask if we could at least get an additional a status or a docket. I guess something like today, similar, a docket call or a status.
Have you been in contact with Mr. Linder or Mr. Estrada?
Other than forwarding the motion to substitute the motion and the order, so they would sign the order to substitute counsel. I've had no additional contact with them. Michael Stevens, I've had contact with pretty consistently in the last couple weeks. My understanding, Judge, is they had submitted, or Mr. Stevens had submitted a device, and I think it was sent to Mr. Linder. But I'm not, that has not been told to me by Mr. Linder or Mr. Estrada.
And remind me which Mr. Stevens?
Michael Stevens. He's listed on the case, I think, as co-counsel. And he's not off the case. He's still co-counsel.
So it looks like originally it was Estrada and Stevens, and then it was Linder and Stevens and Estrada, and so now it's Stevens and you.
Yes, Your Honor, that's correct.
Okay, so Mr. Stevens has been on this case longer than you, and you're saying that he's already gotten a digital discovery?
Well, I know he submitted the device to get the discovery, but I don't think it was sent to him. I think Mr. Linder ended up getting the discovery.
And who's considered lead counsel on this case?
At this point, I am, Your Honor.
Okay, and so who is Mr. Stevens then? Is he just co-counsel?
Just co-counsel, yes, Your Honor.
Okay, but he's doing all of the requesting of the discovery. Is he having the negotiations as well, or?
Well, Your Honor, at this point, I mean, I have actually had contact with Ms. Heisel about discovery. In fact, she had sent me the paper discovery, and I immediately responded with, is this all the discovery, or do I need to send you something to get additional discovery? And I got the response, I think this morning, I believe, or it was late last night maybe, that there was additional discovery, and I just needed to bring a device or send a device. But I have no problem with asking Mr. Linder if he will, but I guess my only concern is since that was coming from Mr. Linder and not the state, I just want to make sure that that wasn't going to be an issue, that since I got it from Mr. Linder and then that some issue came up with this piece was in this discovery, but this piece wasn't. So I just figured it might be safer just to ask the state to give a fresh copy.
Go ahead, Ms. Heisel.
Thank you, Your Honor. Ms. Melton is letting me know that Mr. Linder is the person who requested the previous audio visual discovery. That's who she sent it to. I was aware Mr. Stevens was involved in this case, but I've never talked to him or discussed this case with him. To my understanding, we've never shared discovery with him. It was always Mr. Linder was the point of contact. Mr. Fratter, since he got on the case, has been very diligent about getting signed up for our, in fact, I think this is the fastest anybody has ever successfully signed up for our portal and gotten the paper discovery. And he is letting us know that he is going to get us, I believe there's like 11 DVDs and 4 flash drives involved in this case. It's a lot of discovery. And so he has let us know he is going to get us some kind of external storage that we can put everything on one unit instead of piecemealing it together. I know Mr. Schmidt is the defense attorney for the co-defendant, and we've had issues with Mr. Schmidt about trying to do it in pieces and not getting all the pieces all in one place. So a state is not opposed to giving Mr. Fratter some additional time, because I do know that this case has a lot of information involved.
Okay. All right, so what we'll do is we'll set Miss Dobby then for a status on discovery. And so just, Mr. Fratter, tell me what you're going to do to obtain that discovery. Just go ahead. You're gonna take your devices to, what are you going to, you tell me what you're going to do so I know how much time it's going to take to get.
Well, based on what I'm hearing with the DVDs and the flash drives, I guess what I'll probably do is go and buy, like a terabyte portable drive, and then I'll express mail it over to Ms. Heisel at the Manzan County District Attorney's Office, and then however long it will take them to get that copied. So at least, we can get that done. And I said I did get the access to the other discovery, which I'll start pulling and printing as quickly as possible. But I have tried, Your Honor, knowing that this case has sort of been going and sitting, and to make a valiant effort to get going, to get on track.
All right. So what I'll do is, it's going to take you some time to get that done, and then I want to give you time to actually review the discovery. I could set it as late as November 22nd. That gives you 2 months.
That would be great.
And then have any of your pretrial motions and the pretrial motions I'm interested in seeing, or any of your anything that's going to need to have an evidentiary hearing. Those are the ones I'm really the most concerned about. Limines, I'm not. And I hope you're aware. If not, you need to be aware of this. The court has a standing pretrial order on criminal discovery. So before you go file motions to disclose experts, that's already been ordered. Before you ask for criminal histories, that's already been ordered. So get a copy of that, and it'll save you time.
Yes, Your Honor. Thank you.
All right. So are you available on November 22nd? That's going to be the Monday before Thanksgiving. That's the only thing.
Yes, Your Honor. Absolutely.
Sorry, it's going to be the Tuesday before Thanksgiving. So, okay. All right. The court will set Ms. Dobby then for pretrial on we'll set it for pretrial on November 22nd, and that'll be at 1:30.
Okay.
And so this will be the only notice that we're going to give Ms. Dobby here. Will be this notice in open court. So Ms. Dobby, we'll see you on November 22nd at 1:30.
Thank you, Judge.
All right. Thank you, Mr. Frater.
Thank you very much, Your Honor. May I be excused?
Yes, sir. You may.
All
Good to see
right,
you.
thank you.
All right. Is Mr. Manning available for the Henderson County Zoom? We have on Dusty, Lynn, Rhodes. Mr. Manning, can you make yourself available?
Yes, Judge.
They just popped in a moment ago. Give them just a moment to connect. All right, Mr. Manning, I don't know what the delay is. So if you want to go about your business, we'll wait to see if the jail turns on their camera.
Yes, Judge.
We have any other counsel that's ready, or Mr. Manning, if you're ready on any other cases?
Judge, yes, I can announce on several of my cases.
All right, let's go ahead.
Judge, if we can have Mr. Lyons.
Right, court calls Keenen Lyons, CR 22-152, 276, arraignment on the charge of burglary of a habitation. Are you ready to go forward on that, Mr. Manning?
Yes, Judge. Mr. Lyons' name is spelled correctly. He understands the charge against him, range of punishment, has pleaded not guilty to that charge at this time, but he has to be set on a pretrial docket.
All right, court will enter Mr. Lyons' plea of not guilty into the record. In this cause number, find that he has waived the formal requirements of arraignment. We'll set this for pretrial along with docket call and CR 22-152. How much time do you need for pretrial on this burglary charge?
Judge, I believe I received the DVDs in this case this week. And I believe I have everything I should need to review the case. There are a couple of issues that Mr. Lyons and I can take a look at. But I believe we should be able to do that in time to be ready for the October 13th docket.
Okay, court sets docket call 10:13 and pretrial 10:13 at 1:30. All right, Mr. Rhodes, it'll be just one moment, okay, sir?
Yes, sir.
All right, court calls CR 22-249, State versus Dusty Rhodes. We're set for arraignment. Before we proceed, Mr. Rhodes, are you represented by any attorney on this evading arrest or detention with a vehicle here in Van Zant County? I know you have charges in Henderson and Van Zant, but do you have an attorney on your Van Zant charges?
It's supposed to, I hired Justin Weiner and my kid for the evading.
Okay, here in Van Zant?
Yes, sir.
Do they represent you in Henderson?
Yes, sir.
I don't show any type of motion to substitute here in our county. Mr. Manning has told me this morning that he has seen some email, I believe, exchanges referencing the fact that you may have hired Mr. Weiner or Mr. Head. Have they told you that they're representing you here?
Not on the unauthorized use of a motor vehicle. They're not. Only on the evading. I've given them all the money I have, so I don't have any money to hire them for the unauthorized use of a motor vehicle. I didn't even know I had that charge. It's from 2011.
Yeah, and I'm not sure, I don't show it on my docket today. Ms. Heisel, are you showing an unauthorized use of a motor vehicle? Mr. Manning, do you know what Mr. Rhodes is speaking to?
No, Judge.
Go ahead, Mr. Manning.
When I received notice that Mr. Rhodes' case would be taken over by Mr. Weiner, Mr. Head, I went ahead and offered up my discovery and information to them and closed out my file, so I don't have it with me. But my only understanding was I was only appointed on the evading arrest.
Judge, I do show that Mr. Manning was appointed on the evading arrest. There is a CR 13-00026 UUNV that is at large status. We have received some communications from Mr. Weiner indicating that he does intend to represent Mr. Rhodes on both of those, but we don't have a formal letter, but I do see that Ms. Melton has changed the discovery portal over to Mr. Weiner and given him discovery on both of those cases. So I'm not sure if he just emailed her and let her know that they would be, but his name is on the discovery portal for both charges.
Yeah, and so I have any substitute or a letter. So, all right. So based on Mr. Rhodes' assertion about Mr. Weiner, accompanied by the evidence from the DA's office and from Mr. Manning, then Mr. Manning, I'll discharge you from the court-ordered appointment of Mr. Rhodes. I'm going to ask my coordinator, Ms. Taberham, to contact Mr. Head's office and Mr. Weiner and determine if they can make an appearance today so that we can go forward on an arraignment. So What I'm gonna do is, Mr. Rhodes, I'm gonna turn off your camera for a second and mute you, and as soon as I get a hold of the attorneys, then we'll bring you back in, okay?
Yes, sir, Your Honor.
Thank you, sir.
I don't see Ashley was no longer. She said she had done it.
Ms. Heisel.
Yes, sir.
Figured it out. Miss Abraham figured it out. You see this letter here?
Yes, Your Honor.
So CR 13 is a motion, or CR 1326 is a motion.
Gotcha.
And so, but the alleged evading arrest or detention of the vehicle was from January of 21. So I don't know if this letter is saying he represents on both, and they only filed it in the CR 13.
Judge, I believe that's correct because I believe that at the time, maybe the CR 22 case, the evading was unfiled. It looks like that wasn't filed till July of 2022. So it's very possible. Yeah, so this letter predates the indictment on that, which I'm assuming that's why there's no cause number attached to it and therefore no filing into the case.
Well, that it looks like to someone else reading it, it looks like that the CR 1326 motion on the alleged evading arrest or detention versus the UUMB and unindicted. So
Oh, I got you.
nevertheless, this letter only got filed in the reference cause number because there's nowhere else to file it. So once he was indicted, this letter didn't follow that case. So what I'm going to do is reset Mr. Rhodes to the evidentiary date on October 27th, and we'll send notice on both cases to Mr. Weiner. So I think that's probably why.
Okay, sounds good. Thank you, Judge. We'll make a note on our side.
All right, and let me get Mr. Rhodes back in here. I know that he can hear me, but I want to make sure he can acknowledge it.
And Judge, whenever you're ready, I have Mr. Hart and Mr. Ashmore.
Yeah, yes, I don't have Mr. Ashmore, so I'll let you know as soon as I see Mr. Ashmore. Deputy Everett, I do have Mr. Mark Trainer on Zoom. If Corey Butler is available, we can do him next.
Let me go get him. He's not on my list.
Corey Butler, he should be. He was the last one on my docket. Corey James Butler, CR 2262.
All right, let me go get him.
I think. All right, Mr. Rhodes. I'm confident that you can hear me. However, I've got you muted and I turned your camera off, and I know you're probably waiting on jail staff to turn that back on for you. Go ahead, Mr. Everett. I'm talking to.
I just found out Mr. Butler's in Henderson County.
Oh, he is in Henderson County? Okay. All right, well, I'll call him in just a moment. So for Mr. Rhodes, the court is going to reset you until October 27th, and we'll send notice to Mr. Weiner. We did find a letter of representation in your older case that was not connected to the newer case once it got indicted. So that's why he didn't have notice to be here today. So we'll get that taken care of, and we'll see you back on October 27th on the contested docket on your motion or vote. Stay in contact with your attorney, Mr. Weiner. Find out. All right, I'm going to pull in Mr. Trainer. For Mr. Butler.
Middle state is on his way. He got stuck in there.
Well, I had Mr. Trainer, but I brought him in, but he does not appear to be here now, so. Guess we'll hurry up and wait. You bring in Mr. Maybe this is Mr. Knoll.
Sorry, Your Honor, I pressed the wrong button.
Yeah, nothing like that. Oh, this is, no, this is
Nope.
not, it doesn't even look real. It is though. Yeah, I mean, it is. How is that even possible? To get, and then if you look at this.
On your end, Mr. Trainer.
Back,
One more time, Your Honor.
Is that noise on your end? Is that conversation on your end?
Oh, yes, Your Honor. I'm sorry. Yes, they're over there. I apologize.
Yeah, tell them when they're talking, I can't hear anything but them.
Yeah, not a problem. Hey, the judge can't hear me. All right, sorry about that, Your Honor.
All right, this is cause number CR 2262, State versus Corey James Butler. I think we had a status. Is Mr. Butler still in federal custody?
He is, Your Honor, and it looks like he is going to be doing some prison time with them. Looks like he's going to be taking an offer.
Okay. Is he being held in Henderson County, or do you know where he's at?
I believe yes, it is in Henderson County that he's being held at, Your Honor.
Okay. All right. State, any announcement on state's intentions with this case? Do we want, if you're wanting to proceed, we may need to get a hold of him before he's shipped out if he's taking a federal sentence.
Your Honor, I am, this is not my case, but I am confident that upon a plea in the federal case that we would be willing to dismiss our charges. We don't have any documentation of a plea for that. Perhaps Mr. Trainer could get that for us, and then we could submit a dismissal with receipt of that information.
Mr. Trainer, can you advise the court on what the plea is federally?
Yes, I just got the phone number for his attorney on that one, and so I will go ahead and get that plea paperwork over to you.
So you're not representing him on the federal charges?
No, sir, I'm not.
Okay. All right, then what we'll do is I'll just set this for another status. Are you available on October 25th, Mr. Trainer? If y'all decide you want to dismiss this case, and obviously we can, you can submit that and I can roll on it without a hearing. Otherwise, I'd like to have another status on Mr. Butler.
Understand, Your Honor. Let's see, October 25th, you said?
Yes, I could do it earlier. I can do October 11th, 13th, or 25th.
25th is fine if we can be in the afternoon.
Yes, sir, it can be. All right. And you can be via Zoom as well if you need to.
Oh, I appreciate that, Your Honor.
All right, so court will set this for a plea custody status on October 25th at 1:30. Thank you, Mr. Trainer.
All right, thank you very much, Your Honor.
Have a good day.
You too.
Mr. Knoll, I'm ready when you are.
Good. Okay, Judge, I think we've got, I think 3 of mine there today.
Yes, sir. Let me change your name to Kurt Knoll instead of Beverly Melantree. I don't want you to impugn her reputation.
That'd be good.
I was just about to say, Miss Melantree looks awful different today, Judge.
The hair, probably.
It's there, for sure.
Judge, would it be possible on Mr. Marley to get a very brief breakout?
Potentially, you may have to wait a moment.
Okay.
I can't break him out without using the jail court, so
Okay, I'm happy with that. I can wait.
you can wait for a little bit on that, maybe when we have a break when Mr. Manning's done. Are you ready on Printavious Moorhead?
Judge, I am. I haven't been able to actually, be honest, spend enough time with him yet to figure out.
Deputy Everett,
I'm sorry.
I'm trying to see if Mr. Moorhead's available.
I actually can't see in the room enough, so can't tell if he's there or not.
You're muted, Deputy Everett.
Mr. Moorhead's on his way.
Okay, what about Mr. Ibarra?
Same thing. They're coming right now.
Okay, what's going to be your announcement on Ibarra? I showed that was docket call / plea. Were you going to plead Mr. Ibarra today?
Judge, I believe we have a plea agreement, but I don't know, maybe even a couple of weeks ago, I haven't had a chance to get over there and get the plea documents to review them, Mr. Ibarra. They may be ready already. He has 2 cases, I recall. I think they're I think the offer was 10 on both.
Judge, state forwarded plea paperwork on both Mr. Ibarra's cases and Mr. Marley's case to the Van Zandt County Jail. We weren't aware that Mr. Knoll was going to be appearing by Zoom. So
Okay.
Ms. Tabraham carried the paperwork physically over to the jail.
Says that what happened is that they had a trial that went over, that was supposed to be over midday Wednesday in the 114th. I was sitting the 114th this afternoon, but the jury came back with a guilty and the guy's going to the jury for punishment. So they're back in trial. So kind of messed up my afternoon, so to speak.
So we're going to need to reset Ibarra and Marley.
And Judge, I believe they're both will be pleased after I go over the paperwork. The sooner the court can set them, I'll get over there probably Saturday.
All right, Mr. Moorhead, come on up, sir. All right, this is cause number CR 21180, State versus Printavious Moorhead, set for pretrial. Your announcements, Mr. Knoll.
Judge, Mr. Moorhead and I think I'm I don't remember really, the second or third or maybe even the 4th lawyer on the case. I think he's seen most of the discovery, assuming it was all available to the other counsel. He and I, mainly my fault, I just had too many things going on over here in Smith County to sit down and review the same information with him that he has reviewed. So to be honest with the court, I'd need another pretrial with Mr. Moorhead.
All right, are you available on October 11th or 13th?
Let's do the 13th, Your Honor.
All right, court sets Mr. Moorhead for an additional pretrial on October 13th.
And Judge, could I ask the status? We discussed at the last setting, I believe it's aggravated robbery charge is filed downstairs because you were recused on it. And I know there was some discussion about a motion to transfer this charge down so that both charges could be on the county court at law docket and get that reset for trial. Mr. Knoll, do you have any status update on that?
I haven't filed the motion to transfer. In fact, I just, as you indicated that, remembered that the court apparently had a conflict. So we do need to get this case transferred down to Judge Winters.
So it is still your plan to do that?
I think since the court has recused, Judge Martin has recused himself on the other case, I think we pretty much have to. Or at least that would be my opinion.
Well, this is a bill jumping case, correct?
I believe that's what it is, yes.
And the bill jumping was alleged to have occurred when?
Because I don't remember when it was alleged to occur, but I think it was based on this case, or based on the case that's already in the Judge Winters court.
Judge, I have the date of offense being May 24th of 2021. I believe, if memory serves, that he was set for trial downstairs on that date and failed to appear.
So I would say that I'm not recused because this is a new offense alleged at a time. If the previous case that Mr. Moorhead had, I was recused because I was an active prosecutor on the case during my time in the DA's office. That is one issue. Bail jumping at a time in which I was already on the bench does not automatically recuse me. However, with that said, out of judicial economy, of course, I will move it down, but it will not be on the ground of recusal. It'll be on the ground of judicial economy, and if Judge Winters accepts it, then I'll just send an order down there so that they can run concurrent.
And if anybody knows, because I don't know, who was the attorney of record on May 24th, 2021?
And have one. That was my meeting was for, that was my court date was for me to get another lawyer. I tried.
Well, there would have been somebody that would have been relieved, or I
That was
guess.
Joshua Brown.
Just hold on.
Yeah, Mr. Moorhead, what are you asking, Mr. Knoll?
I think he was indicating that there was supposed to be another lawyer coming on, but I don't know who the lawyer was back in May 24th of 2021. I think there was actually retained counsel on this case at one point.
I don't recall, Mr. Knoll, I'm sorry.
Okay.
You see an amended appointment. Let me see. Mr. Moorhead, who has represented you before Mr. Knoll?
Joshua Brown, he was an attorney out of Fort Worth, but I fired him because, well, I guess he wanted to get out the case too, but the court that I actually missed on May 24th, 2021, it was for me to come and get a new court appointed attorney. And I didn't make it. It wasn't for trial.
Okay. Does that answer your question, Mr. Knoll?
I think it does. So there's been one other lawyer. I think that was retained counsel. Is that right? Because it sounds like what it would be out of Fort Worth.
No, sir. It was a court appointed attorney.
Mr. Graham was on the court appointed list early on when I first came on, probably. He may have actually been appointed counsel before I got on the bench.
Yeah, I thought he said the name was Joshua Brown, but it's Joshua Graham.
Brown. Yes, sir.
Graham. And Mr. Graham did have several cases here. Was on the court appointment list, I think prior to Judge Winters and I taking the bench, because him being in Fort Worth, we removed him from the appointment list due to the distance.
Makes sense. Okay.
In his principal place of practice. All right, so the court has, does that answer your question too, Ms. Heisel? So what I'll do is I'll just go ahead and draft an order and ask Judge Winters if he'll accept this case, just so that they can run together, so y'all can work on resolving those at the same time.
Thank you, Judge. And
All right,
that
thank you, Mr.
October 13th setting, correct?
Well, so that's what it's set for me. And so if we get it done before then Judge Winters will schedule it on the docket that he wants, but we'll keep it on the 13th so that we can make sure that it gets done.
Okay, thank you.
All right, thank you, Mr. Moorhead. All right, Mr. Ibarra. CR 22-159-160 set for docket call plea today. Go ahead, Mr. Knoll.
Judge, I believe we have a plea agreement in this case. As I indicated earlier, sometime, hopefully tomorrow. I know I've got sittings tomorrow at 1:14 in the morning and in the afternoon, possibly at lunch. If I can get plea papers made available then. I think the court said they actually were taken to the jail this afternoon, then I can get over there and we can go over papers and then be ready for the soonest setting the court would have available.
Let's see, I've got I could squeeze Mr. Ibarra and Mr. Marley on next week's 27th docket. That's a Tuesday. Do you want to do that in each case?
Judge, I would say yes. I'm also, though, have a trial setting coming up, but lately I always wind up number 2 or number 3 because people have been in jail longer than my clients. So let's go ahead and try to do that on the 27th, and that would be at 1:30.
That would be at 1:30. Well, you know, if that occurs, if you'll do the plea papers like on Saturday, like you had said you may do, if you get it all signed, then you could do the Zoom, you could do a Zoom plea as long as all
Okay.
the signed and explain to your clients. And if you need to ask the judge if you're in trial, if you could take a break to do 2 pleas, then we could accommodate you that way for sure. But
Okay,
paperwork has to be reviewed and signed by counsel, and
right.
then they have to have that and have to have you there to be able to ask those questions.
Judge, I'll get over there sometime tomorrow, as long as I can get plea paperwork. I'll just need to know where it is and I'll get it picked up tomorrow. Maybe at lunchtime, but I'll figure that out.
Ms. Heisel, do we want to email or
Em-
just leave it there for pickup, or how do you want to handle that?
Your Honor, I handed them off to Miss Taberham. I believe she has them at the jail. If she wants to just leave them back at Bookend and let Mr. Knoll go make arrangements, I'm emailing Miss Abney now that the state will need to prepare a judgment with the November 27th date on it, but all the admonishments and everything else can be filled out ahead of time.
That would make sense. If it could be left at Bookend, that way if I showed up at 6 o'clock tomorrow evening, that'd be fine. I can get them anytime.
Okay. And do you still want the breakout room with Mr. Marley?
I do, if I could have, it's not going to take long, maybe less than 5 minutes, put it that way.
And do you understand that the breakout room, there's not going to be any privacy on Mr. Marley's end because he's going to be in that room. He's not going to be taken to another room because I don't have another device there.
That's okay. I just need to give him some information and then we can talk some more when I get there, hopefully tomorrow.
Okay, but we do want to reset him to the 27th right now.
Yes, Your Honor.
All right, Deputy Everett, if we can fill out a reset form, and Mr. Marley's in the room, is he not? Okay, I see.
Yeah.
Mr. Marley, you've heard everything we've talked about?
Absolutely, Your Honor.
Okay, all right. In just a moment, I'm going to give you a chance to talk with Mr. Knoll, but we are going to reset you for plea next Tuesday, you and Mr. Ibarra. So both of you gentlemen, if Deputy Everett needs you to sign that reset, then go ahead and do that. Is Mr. Manning ready to move forward with any of his pleas? If not, I can set this.
Yes. And what time were theirs on the 27th?
That'll be at 1:30.
Did Mr. Marley just leave? Who's where? That's him.
All right, go ahead, Mr. Manning.
Did we on Mr. Jeff Hagan?
All right, Jeffrey Hagan, CR 22, 180, 181, 182. Are we pleading Mr. Hagan today?
Yes, Judge.
All right.
We're going to be proceeding on CR 22, 180 with dismissals in 181 and 182. The plea agreement is going to be for a lesser included, or sorry, a attempted aggravated assault against a public servant. I'll note the same issue we had previously, that the judgment says that it is for an information instead of an indictment.
Good. What are the terms of the plea?
The terms of the plea agreement are going to be that under the second degree felony, attempted aggravated assault against a public servant, that the finding of guilt be deferred, punishment assessed at 10 years community supervision, a fine of $10,000. They got 1245, the other two cases. There's the fine of $10,000, as well as court costs, the amount of $290, and reimbursement fees in the amount of $520.
520.
That's correct.
All right, Mr. Hagan, if you'll raise your right hand, sir. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
So we got.
All right, put your hand down. Mr. Hagan, are you a United States citizen who reads, writes, and speaks English?
I am, Your Honor.
And have you ever been diagnosed with any type of mental condition?
I have not, Your Honor.
You're represented by your attorney, Mr. Manning. Do you, are you pleased with his representation?
I am, Your Honor.
You feel like you've had enough time to talk with him about your case and have all your legal questions answered?
I have, Your Honor.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir, I understand.
Mr. Manning, do you believe Mr. Hagan to be competent today?
He is, Judge.
Have you discussed with him the advantages and disadvantages of a deferred plea and his rights as they pertain to this case?
Yes, Judge, we've discussed them extensively.
Okay. Mr. Hagan, you are charged by indictment with a first-degree felony offense of aggravated assault against a public servant. However, you've heard the plea agreement recited to the court. Charge would be, you would be pleading to a lesser charge of attempted aggravated assault of a public servant, a second-degree felony, which does carry a range of punishment of not less than 2 years or more than 20 years in prison, and a fine not to exceed $10,000. In addition, you would have court costs, reimbursement fees, and the other two cases, both ag assault public servants would be dismissed under the plea. Is that your understanding of the plea agreement?
It is, Your Honor.
Can you understand how a deferred adjudication works?
Yes, Your Honor, I do.
You understand that if the court approves this and places you on deferred, that if you violate any term of that community supervision, the state could file a motion, bring you back for a hearing. And if they prove that you violated your community supervision conditions, they could ask the court to adjudicate you, to revoke your community supervision, and assess punishment anywhere between 2 to 20 years in that legal range. You understand that?
I do understand that, Your Honor.
Okay. All right, then at this time, I'm going to ask you, how do you plead to attempted aggravated assault of a public servant?
That's guilty, Your Honor.
You're pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, Your Honor.
Court accepts the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to states one, Judge.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Nothing, Judge.
Ms. Heisel, is there victim notification at all?
Judge, I don't believe so. This involved local law enforcement. And I don't believe, I know one of the alleged victims was our investigator, John Morrison. So I don't believe that formal notice has been sent to anyone.
And do you believe the victim in this case to be supportive of the plea?
Yes, Your Honor.
Okay. If you can go ahead and give me the facts to support the plea.
Yes, Judge. On April 5th of this year, Mr. Hagan's, I believe it's his girlfriend, somebody who had a relationship with, was in a pursuit with local law enforcement from multiple agencies. And that female called Mr. Hagan and essentially gave him the coordinates of that pursuit where she was evading with a motor vehicle. Mr. Hagan arrived on scene there and essentially tried to physically create a barrier between that female and law enforcement by driving his vehicle towards local law enforcement's vehicle such that they could not continue their pursuit of her. They were eventually Mr. Hagan wrecked out and was detained, as was the female. But that is the basis for the aggravated assault, was him driving his vehicle towards law enforcement to intervene in that evading.
And were any injuries suffered or sustained?
No, Your Honor.
Mr. Manning, anything further?
No, Judge, nothing from defense.
All right, then based on the evidence and the recommendation of the state of Texas, the court will follow the plea agreement. Court will find that there is enough evidence to convict Jeffrey Ray Hagan of attempted aggravated assault against a public servant. The court will defer a finding of guilt, place him on 10 years community supervision, order him to pay a $10,000 fine, $290 court cost, and to reimburse Van Zandt County $520. Court will dismiss under section 1245 CR 22-181 and 182. Mr. Hagan, you're hereby remanded to the custody of the Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Go with the deputy to be fingerprinted, and then you'll speak with the probation officers for more information.
Thank you, Your Honor.
You're welcome. Are you ready now, Mr. Manning?
Judge, ready on Mr. Dustin Sewell?
Sewell? Mr.
Yes,
Sewell, you'll step up. Dustin Allen Sewell, CR 22-253, set for arraignment. Do you have that indictment or do you need me to assist?
Judge, I do not. I have discussed it with my client though. He understands the charge against him as well as the enhancements. He understands the range of punishment as it's alleged in the indictment. And his name is spelled correctly. At this time, he's pleading not guilty and request be set on the pretrial docket.
All right, the court will find that Mr. Sewell has waived the formal requirements of arraignment and will enter his plea of not guilty into the record. And the court sets pretrial. Do you want that October or November date, Mr. Manning?
Judge, if we can get the October date.
All right, court will set Mr. Sewell for pretrial on October 13th at 1:30. Mr. Sewell, if you make bail in this case, your hearings will be at 9 a.m. rather than 1:30. Okay, only when you're in custody will you be at 1:30.
Ready on Mr. Warner?
Taylor David Warner, CR 22-197. Mr. Warner is set for docket call.
Judge, we received a new offer from the state yesterday. I discussed that with my client today, and he is wishing to accept that offer. We get him reset the earliest possible ability for a plea.
Okay. Do you want to do it next week?
Judge, I believe I'm available next week. Hold on one moment.
That'd be the 27th. I have a couple slots that have become available. If you want it that quick.
I'm sorry, Judge, we're having difficulty hearing over here. There's quite a bit of noise.
So you indicated that there was a plea that he wanted to accept. Is that right?
That's correct, Judge.
Yeah, I could do it on next Tuesday, the 27th in the afternoon. If that gives
Judge,
you.
I'm in Kaufman County next Tuesday afternoon, but if possible, if we do it on the Thursday.
I'd rather not, because that's evidentiary docket.
Can we do it Tuesday, just a little bit later?
In the afternoon?
Yes, Judge.
Like if you could be here by
3.
Yeah, that would be fine.
Okay.
As long as it's 3 and not 5.
And that's going to be on the 27th.
Yes, it's either that or we set you for October.
Judge, what's the date in October?
13th.
Okay. Judge, if we can take that, my client said he's okay with waiting.
Okay. All right, court will set Mr. Warner then for plea on October 13th. That'll be at 1:30.
Judge, Miss Platt.
Jeanette Kelly Platt, CR 0834, CR 0835, motions to revoke. Go ahead, Mr. Green.
Judge, as you know, this is a quite an old case. It's so old, in fact, that it was not in the online portal discovery or in digital format. My understanding was that Mr. Woodwike was going to get that transferred over and released to me. I'm not sure if it has been released, but we are still waiting a possible resolution. I've requested a resolution on this case because it is so old, because of this Platt's substantial compliance with our conditions of probation. If we could get this reset to the contested docket, I believe we should be able to get some sort of resolution done before that point.
Okay. October 27th.
Yes, Judge.
All right, court sets Ms. Platt for contested hearing on her motion to revoke October 27th at 1:30.
And Judge, if I'm able to work out something sooner, would you entertain her case being resolved sooner if we could figure something out?
Absolutely, yes. As long as I have room on the docket, then yes, we can do it as soon as we can.
Thank you, Judge. Mr. Vigil.
Dallas Vigil, CR 21-251-57. Motion to revoke.
Judge, I received the discovery on Mr. Vigil's case. I'm going to request to be set on the contested docket on 10/27.
All right, court sets Mr. Vigil on that date. That'll be at 1:30.
And Judge, I believe with the exception of Mr. James, who's set for a writ, I believe that concludes the remainder of my business.
You said Mr. James
Sorry, James Dennis.
Dennis. Let me see. I'm not sure I have that on my docket. Yeah, I don't have that. And you had Miss Abraham set that today?
I believe I received notification I was set today. Let me double check and I'll inform the court in just a moment.
That's okay. Hang on. Stay where you're at. Let me look it up too. Do you have a writ number?
Yes, Judge.
Go
Yes.
ahead. What was this? It's last name Dennis, first name?
James.
C.
The writ number is writ 2282.
2282. Show that set 929.
Okay, thank you, Judge. With that, then I believe that concludes my business. May I be excused?
Yes, thank you, Mr. Rainey. Mr. Stevens, are you ready with Mr. Aguado?
Yes, sir, I am.
Come on up, Mr. Aguado. All right, court calls. Over here. Cause number CR 21-317, State versus Joseph Dan Aguado. And we're on our usual status with Mr. Aguado. Ms. Taperham has given us an update that Terrell State Hospital has now number 82 as of September 16th. So about a week ago, he's moving up, but 82 is not a real bad number. So how are you doing, Mr. Aguado?
All right.
Doing okay?
Yeah.
Good. Well, you're looking better. Mr. Stevens, any concerns regarding Mr. Aguado?
No, Judge, just trying to get him some help as soon as we can. I visited with him and he does seem to be a little bit better than the last time I saw him, which was almost a month ago.
Do you know if Mr. Aguado is taking any medications that he's been prescribed while he's been in custody?
He has been.
Yeah. Okay. Mr. Aguado, have you been getting medications from the jail staff, from the nurses?
Yeah,
You've been taking those?
yeah,
Good. Do you feel like those are helping you at all?
yeah.
Good. Okay. All right, Mr. Aguado. Well, it's good to see you. It looks like you are doing better. I hope that we can get you to the hospital as soon as we can so that they can, work with you and talk with you and get you better. Okay. So that we can get you resolved and get you out of the jail. Okay.
All right.
All right. Mr. Stevens, if you've got your calendar,
Yes, sir.
are you available on Christmas Day?
Oh, sure. Always, Judge.
I just want to see if I can catch you off guard. What about Thanksgiving? You're good on Christmas, you're good on Thanksgiving, right? What about November 8th or 10th?
November 8th would work great, Your Honor.
It's either that or we could look into December. But if November 8th is fine, then I would like to keep a tab on Mr. Aguado and make sure everything's okay.
Yes, sir. Judge, I do start a jury trial that Monday. It probably will go into Tuesday now that I'm thinking about what it is and all that.
You want to try the 10th?
Yes, sir.
Okay.
I'll be through by then.
Okay. All right. We'll set Mr. Aguado then for another status on November 10th. That'll be at 1:30. All right. Thank you, Mr. Aguado. Thank you, Mr. Stevens.
Thank you. I'll be excused.
Yes, sir. Thank you for being here and seeing your client. Right. Let's see.
Yes, sir.
Do we have anyone else other than Mr. Marley with Mr. Knoll?
We have Mr. Hart here for Mr. Ashmore.
Yeah, I've not seen Mr. Ashmore. He's not logged in. So Deputy Everett, what I'm gonna do is I'm gonna create a breakout room. You'll go ahead and join that with Kurt, then we'll let him do what he needs to do. All right, Deputy Everett and Mr. Knoll, you should be getting it right now.
Got it.
And then Deputy Everett, just return whenever you're done. All right, Deputy Everett, I don't see Mr. Ashmore. He's not logged in.
Miss Patty said that he was about to be there, so.
No, he's not coming in. He was
I
gonna.
know. She said he's about to be on Zoom.
All right, let us go call him. If he's not here, it's 3:45. If he's not logged in next 10 minutes, then we're just gonna call it a day.
Sounds good.
All right, thanks.
10 minutes. What? Mr. Ashmore was in court this morning, but he said he had court, veteran court in Rockville at 1 o'clock. So he said that he would be via Zoom. You'll know he's a sort of short, stocky guy with big beard. I've had about 41. Here's almost. That seems like we got the job on. I have heard. But he seems to do his fine, bro. He does come in late sometimes, but that's because it's coming from all. I think he's the main state. Yeah. I heard you that state's better. That's one thing. I ain't never met him, but he's been pretty good. Every time that I've seen him, guys calling shot. Very good. I'm from around here, though. I'm from Point. I've seen this. You ever been arrested in camp? No, I've been stopped. I've got a ticket in hand for correct name. I've written a bunch of those. I'm at Dollar Tree. I've seen you. I mean, it's my girlfriend. She slapped the shit out of me.
Probably deserved.
In the parking lot, somebody called the police.
Yep.
The police come, we're sitting there.
Deputy Everett.
Yes.
Hey, I just want to let y'all know you aren't on mute, so just wanted to give y'all that warning.
All right. Yep. Yep.
All right, Mr. Ashmore, can you see and hear me okay?
Yes, Judge.
All right. All right, let's see. Mr. Hart, if you'll step on up, CR 22-146, we're set for arraignment. Have you had a chance to go over the indictment with Mr. Hart in this case, Mr. Ashmore?
Not yet, Judge. We've been trying to coordinate getting that shared with me. It may be in my inbox, but I left Veterans Court just a moment ago and haven't had a chance to get that yet. Okay. If the court be kind enough to share that, we'll do it right now.
Give me just one second.
Judge, I do have it in my email, if that helps.
Said the film is 220.
Can you see that, Mr. Hart?
Yeah, I see it.
Your name is spelled correctly, Jamie Floyd Hart,
Yes, sir.
and you understand that that's the allegation against you, burglary of a habitation?
Yeah, I don't understand how it's burglary when I was living there.
Wait. This is an allegation, okay? Right? Do you understand that's what the state is alleging they understand happened, okay?
Okay.
And that it happened on January 17th, 2022. You understand that?
Okay.
Okay. That it also goes on to say that there was an attempt to commit or commission of a felony offense of stalking. You understand that allegation?
Oh. That's my girlfriend.
I understand that, Jamie, but that doesn't give you the right to commit
I wasn't doing
a
no
felony offense. Hang on, we're going to get to that. These are the allegations that witness or witnesses presented to the law enforcement, which were presented to the state prosecutors. You understand all that, right?
I guess so.
Well, I need you to say yes or no.
Yeah, I understand.
Okay. And then down here, there's a paragraph. It talks about what went down in April of 2011. About 10 years ago, there was a felony aggravated sexual assault of a child. You understand that?
Yes, sir.
Okay. That is a enhancement paragraph that takes this offense to a range of punishment of 5 to 99 years or life in prison. You understand that?
Yeah. Yes, sir.
Okay. You authorize me to enter a plea of not guilty, get your discovery, and work with the state of Texas to resolve this matter, correct?
Yes, sir.
Okay. Judge, we're going to ask the court waive the formal reading of the indictment, enter my client's plea of not guilty, and let me and Mr. Hart have some opportunity to work with the district attorney's office in the resolution of this matter.
Okay, court will find that Mr. Hart has waived the formal requirements of arraignment. His name is spelled correctly in the indictment. Court will enter his plea of not guilty into the record, and we will set this matter for pretrial. While I'm getting that date, Ms. Heisel, will you consult your system there and make sure that there's no complications with potential recusal in this matter? I don't know Mr. Hart. I don't recognize the name, but the date is something that I would want to give some due diligence to. The date of his conviction. All right, so look at your calendar, Mr. Ashmore. I can't remember what we gave you earlier today.
I believe 11 October, Judge, which is a Tuesday, if memory serves. I'm gonna check that calendar right quick.
Yeah, we just.
Yeah, I set one of your cases for October 11th. Figure you're gonna want more time on this one, is that right? If you think you can be ready in that amount of time, I'm fine with setting it for pretrial then. I don't mind setting you out a little bit further.
Judge, let me ask instead for October 25th, please. That will give me sufficient time because of the enhancement, because of the other issue. There's a incomplete offense as well as an allegation of a burglary offense. So it is a little more complicated. So I will be in court on the 25th, if memory's Tuesday, the 25th, for Miss Fowler. Also set that day, and that would be much appreciated if we can do that date, Your Honor. If Miss Heisel office doesn't know.
All right, cool. Go ahead, Miss Heisel.
I was going to say, state has no objection to that date. Also, Judge, I reviewed the CR08 file, and I do not see any conflict existing on the prior conviction with you, Judge Martin, or this new offense was after you left the DA's office. So I don't see any conflict on either case.
All right, great. Thank you, Ms. Heisel. All right, so court will set Mr. Hart then for pretrial October 25th. That'll be at 1:30 if Mr. Hart's in jail, 9 a.m. if he is on bail.
Thank you, Judge. May I be excused?
Yes, thank you, Mr. Ashmore.
Thank you so much.
Good day. All right, I believe that concludes our afternoon docket. In this episode of Have Gavel, Will Travel, you're welcome to tune in, same YouTube channel, same YouTube.
And Judge, I'm headed over to the courthouse. I have a document that requires your signature. If you don't mind hanging on for just a second, I'll be right over.
Come on over to the production set. We'll be here tidying in.
Thanks, Judge.